Good morning, everyone, and welcome to our cyber seminar. Cybersecurity risk and insurance are more relevant than ever, and we're thrilled to have you join us today to explore these topics. My name is Lisa Digenes, and I'm a partner at Bull.
And I am Hanna Olavsen, also a partner at Bull. And together we work as the firm's Department for Technology. And together we'll guide you through today's exciting program. We have a packed program until lunch. Yeah. So we are just going to make a short introduction before the first speaker starts. This seminar is a unique collaboration between leaders in cybersecurity, technology, law, and insurance. DEFENDABLE, CLYDE CO, BEAZLEY, LOCKTON, and Bull. And together we aim to share insights that will help you to navigate the challenges and opportunities in this field.
So just a few words about the participants today. We have DEFENDABLE. It's a Norwegian cybersecurity company offering advisory services, security monitoring, incident response, and security testing. I think their slogan said it all. Don't let your company's cybersecurity risk keep you up at night. Let's make you defendable. And we have CLYDE CO. Henning is joining us online. It's a global law firm with over 2,700 lawyers and around 70 offices around the world. Then we have BEAZLEY, founded in 1986, which has grown from a London market insurers to a global specialty carrier with offices in the UK, Ireland, US, and Asia. And then we have LOCKTON, which is a private company and the world's largest insurance broker with over 100 offices around the world. So we are excited to learn more from these industry leaders and get insight into their experience. And just a few words about Bull. We're a full-service law firm with about 75 lawyers, and we have been around for 160 years. We have one office. And our experience in insurance and technology position us to address the challenges and opportunities in cybersecurity. And we have developed a cybersecurity program with an incident response team together with DEFENDABLE.
And now, over to our first part of the program. Cybersecurity, personal liability, and insurance. What can go wrong? It is a pleasure to introduce Alexander Bjørkhaug, Senior Security Analyst at DEFENDABLE, with more than a decade of experience in the Norwegian Armed Forces cyber defense. Alexander is an expert in malware analysis and incident handling. He also has experience as a dedicated educator at NTNU and a kickboxing instructor at Mudo Gym. And Alexander will give us a presentation that fits his profile to track an attacker from Z to A, examples from real cyber attacks.
All right. So welcome. So today we're going to start off a bit fast, maybe. We'll be going through some examples from real life where I have been analyzing stuff for DEFENDABLE. And it might be a bit technical, but I will try to explain what I'm showing you to try and show you like a story of how we have tracked at least one attacker from Z to A. So yeah, I got quite a good introduction there, but yeah, I have quite a lot of experience within both the Norwegian Armed Forces and now in the DEFENDABLE, where I have been working for about 1.5 years now. And we have gotten a lot of different kind of incidents over the time I've been in DEFENDABLE. So about this talk is that, yes, it's a part war story, like explaining what happened, what we saw. It's supposed to be a bit informative and a bit interesting. And I hope that you will find that as well. I have had this talk at the different venues, and my main audience is often a bit more technical. So today we will try and get it onto a level that everybody can get something out of it. We will focus on mainly one incident with a bit of a side tracking here and there. So what we see in DEFENDABLE or in incident response is that the first thing that's detected is the last thing that's done, which means that when you are a victim of cybercrime, for instance, all of the initial part, like the break-in and all of the first steps, are gone in completely silence. And it's at the end when the attacker has done what they want. If they want to ransomware your environment, or if they want to steal and sell data on the dark web, or for instance, abuse your infrastructure so that you are blacklisted for emails, for instance. And that's like the end of the whole campaign. And that's when somebody detects, like the victim detects, oh, okay, something has happened, we have to have help. So we often end up in a situation where everything has been done and we have to pull on threads to figure out how it happened and how we can stop it from happening again. That's the wrong button. Thank you. So the first information we receive as an incident response team is often a bit flawed at best. There are people that are very stressed, maybe it might be secondhand, that the one that's calling it in got some information from their technical team, technical leaders, and there might be summaries over email, and often we see that the victim or the customer that's been affected by something might have a bit of little knowledge of scale of how big the attack is. They might just see a small part of it, and they also often have quite little knowledge about their infrastructure as well. They might know that they have some servers here and there, and they might be internet connected. But when we start to dig, we see that there's much more exposed, or many more servers that are in effect than they might actually believe themselves. So we always enter into incidents with the information we receive, and we take it with a grain of salt, and we do a lot of information gathering our own. So a little bit of forensics basics is that we have the 5WH, which are quite common when you do some investigation theory. And we will focus on this talk about the how. Most important is how, when we try to figure out how did this happen, how did they move about. Then we'll focus a little bit about what, then where in the infrastructure, that's not too important always, when, interesting but not necessary, why, and who are very little interest when you're trying to figure things out on the fly and very quickly. So step one is understanding the current situation. So we start with this example. First small example is that some small medium business X is hit by ransomware. They hire Defendable to figure out how did that happen and how. What happened and how. The SMBX has high confidence in their own system. They always have confidence in their own systems and cannot understand how they were affected. Defendable checks all sources for technical details about the SMBX before handling, which we often do. We get some information, we go onto the internet and search on their infrastructure on different open, freely available sources. And for instance, we have the SMBX. There's an IP address, some technical details, a lot of different things that are open. But the list here is for the infrastructure that they felt were very secure, they couldn't understand how they got in. All of these are problems. I've never seen such a long list of problems for one single IP address. As they said themselves, they couldn't understand how they got in. So a long story short, it was remote desktop protocol, an internet exposed service that they were giving out to one of their customers, which was the entry point, which was badly configured, vulnerable, and easily exploitable. From the first sign until the ransomware was 983 days. So the attacker was inside of their infrastructure for over almost 1,000 days. The attacker had no fear, fumbled around, trying all the tools, antivirus alerts, firing here and there, but there were no one to view the alert or detect that the alert had happened. So they were just moving about and doing what they wanted. So here, just a little selfless plug. If you had some MSSP MDR service, you might have detected this way earlier over that. The second one, which we'll be doing a bit more on, is the SMBY, which was also hit by ransomware. they hire Defendable. They explain that they just migrated to the cloud, which many customers do. So they don't understand how the attacker got onto their on-site, on-premise systems and infected them with ransomware because they are no longer on system. They are just random computers and everything else in cloud. So this on-site systems are no longer in use. So how did they don't understand how they got in and how they affected their systems on the sites. And as we can see here, this is the same web page that we saw earlier with the video, but this is just a still image. So there's a bunch of open vulnerabilities on their internet exposed server, but there aren't too many opens to the ports, like the service exposed out to the internet. There aren't too many, but there are a bunch of things here. And again, they have full confidence in their systems. Step 2, we have to make hypotheses to work out from. So what do we know? Well, there are ransomware being executed, and there are some vulnerabilities on the web server that is exposed. The initial thoughts are maybe it's ransomware deployment protocol, the RDP protocol, which we saw earlier. But since the web service that we saw didn't have that available, we can't really assume that's being used. So there's something else going on. Since there's only port 480 and port 443 for those who are interested in that. There are some services that we are servers inside of the systems which we would like to analyze when you don't know exactly what's happened. So there are some core servers that are often targeted by the attacker, which we start to look into and go backwards. And all were affected. So we have to start unfolding threads. And where do we begin? Well, we start where a bit of an overview. This is just to show you we're going quickly through this little timeline of things I saw. And we will start where I started, with where the ransomware was run. So here we can see that on an SQL server, for those who are interested in that, on the 28th of February 2024, ransomware was run. We know this, I saw this, and from that point on, all other systems were broken. So how were they able to get ransomware onto the systems? Well, at the beginning here, we have, at the left-hand side here, we have RDP, the ransomware deployment protocol has been used to be able to run ransomware. But how are they able to remote desktop is not ransomware, but the remote desktop into the system from inside of the internal network? Because we can see the IP address is another system inside. So how were they able to move inside from one PC to this SQL server to run ransomware? So then we have to go to that other machine. And on that machine, we can see that just before, a little bit before they moved over, we can see that they are configuring the antivirus to accept their files. They are being detected with some malware detections. But since they are administrator, they have administrator access, like the full access to the systems with the administrator user. They're able to just accept and make the system accept their malware. So how are they able to log in as administrator onto this domain controller, which is the sacred grail of a network? Then we have to go a bit back. On another server, we can also see, let me go back one. We have a successful logon to administer from another system. So we have to go next system to figure out how we're able to log on to this machine from another machine. And from that machine, we can also see malware was saved onto the disk. We have a lot of antivirus detections, a lot of different things that are quite bad and should never be on your systems. And a lot of trial and failure until at the start here, we also have more antivirus. So how are they able to fill the system with viruses and malware? How are they able to do so? And we can see here as they are doing some techniques to go from a normal user into the administrative user by creating a scheduled task. They're abusing the system in a way that should have been detected, but was not detected, so that they can give themselves the access that they wanted. And they are doing that both on the domain controller, the DC1, which is the Sacred Grail, and also this blue Atlassian servers. But still, at this point on the left-hand side, they are a local administrator of this small service. So they go from just a normal admin to the domain admin onto the orange. But how are they able to be local administrator? Because now we have seen that they are able to go from local to more advanced into more advanced again. So we have to figure out how we're able to get into the blue system with administrator. And here's a bunch of different interesting findings for my own sake. Really, is that we can see here that you have this user administrator, like a spelling error, administrator, which they are trying to log on to the system, but they aren't allowed. They fail and fail again because they don't know what they're doing. They're just trying and failing. So at one point, if we go next, pretty much all of these is just them trying to log in to this administrator user and failing until they figure out, we have to give them access to log in. So that's just like a bit of a fun. They are trying, fail until they realize, we have to add them to the right security groups. So this is all just them trying and failing. And now we're on the 19th, 18th. But how are they able to try and log on to the administrator user? How are they able to do that? Well, they are creating, the user is being created the 18th at 12:35. So then the actor is onto the system, able to do actions on the systems, like creating the users. So at this point, they are already inside the system, quite a lot of access, and then they create a user for themselves so they can go about and do more. So again, how are they able to create a new account on the system? And that's and at that point, we kind of were unable to track them anymore into the actual computer's actual servers because we had no more logs. The customer didn't have a good system of saving the logs. We had a lot of missing information, which is the normal in all of these cases because keeping all of this information is quite expensive, but it's very necessary when we're trying to investigate. So sadly, we have no more information to go about on this system itself. But we know that Atlassian server is a web service that you can host on your own premise. Like it gives you something like Word, it gives you Jira, which is a ticketing system. It gives you different kind of services to communicate and work in a team. And Atlassian a server was set up inside on the systems on the victim's premises, but it was exposed to the internet because it's a service they give out to their workers and their other customers. It's cooperation service. So we just went and looked at the logs for this service to see what was going on. And again, it was quite a lot of logs. It's like we're still on the 1st of February, and it just keeps going and going and going and going with different kind of web access. So clicks on link, you generate a log, you generate a entry line, and just normal user activity and bot activity will generate tons of these logs. So we had a lot of digging to do. But we are good at digging, so we were able to figure out that there are some files being used on the systems that are very suspicious, like tunnel, auth2, very suspicious, and these files are not supposed to be on the server. So how are the attacker able to just place malicious files onto the server without having access first? So this tunnel here is quite shortly before they create their user administrator. Well, quite a lot earlier, the 18th, not quite a lot earlier, the same day actually, we see some weird calls to some path onto the systems. Like this text inline is not a normal URL, it's not something you normally see being used a lot. So it was like a red flag. So we have to figure out what's this got to do with the 123.jsp, for instance, or text inline of.jsp at the end. So how are they able to abuse this text inline to drop their files? Well, a quick Google search shows that this abuse of the text inline is a remote code execution vulnerability. Very scary vulnerability, giving people direct access to running whatever they want onto your systems. And this system is online. It's directly connected to the internet. Anybody can do this. They can just fire away and abuse and do whatever they want with your web service. And this was interesting, but with this vulnerability is that this was published maybe a week or two before they went over to the cloud. So just after they were done with this server, they went to the cloud, this vulnerability came out. And since they no longer used the on-site systems, they were no longer updated. But they were still online. So they were just like this in-between limbo where they forgot their own systems, forgot their own their old processes of updating them, making their site completely vulnerable without even realizing it. So we have all of this from the left-hand side, abuse of the web service, creating a user, logging on, messing about, getting access to the domain controller and moving over to more of the domain controller. And here we can see that they're using the malware files that they dropped, like the tunnel.jsp, are being abused to give access to the inside. So that's how they are getting. They're using normal web service to gain access to the inside with malicious files. And what's interesting is that the first part here, they used a changing IP address. They tried to hide their own. They tried to hide their own tracks. But at this point, they turned it off. They went to bed, and the next day they forgot to turn it on again. So on all of these, they used a static one IP address. So we can figure out who they were, like roughly. So what we do to track an attacker from Z to A is like get a scale, understanding of the current situation with the help of the victims, of course. You have to start where you know something has happened. Start at the ransomware, go backwards. Start at the infection, if you know where that is, and go backwards and ask how are they able to do so. And if you don't know where to start, just start with the most valuable target for the attacker. Find the earliest bad sign, ask how were they able to do so, and go further back to figure out how they were able to do that. So how were they able to do X? Maybe they did Y. Let's check for that. And that's pretty much how I work. Thank you, and I hope that was a bit of maybe a bit difficult, but hopefully you have a short window into how an attacker might attack a network. Thank you very much.
Thank you so much, Alexander. It was very interesting to hear your experience there. Now we're pleased to introduce Christian Foss, who leads Bull's security and incident response team. With over 25 years of experience in IT law, privacy, and cyber, Christian combines legal expertise with background both in IT and also as an in-house counsel. And his presentation, who, what, and how regulations, responsibility, and supply chain handling will provide valuable insight into navigating cybersecurity challenges. So, welcome, Christian.
Thank you. Now the boring part is coming, the legal stuff. I'll try to walk you very quickly into the NIS Directive and some background law on liability for board members and other officers of an organization caused by insufficient cybersecurity. NIS is a part of a huge, massive body of new digital legislation from the EU. More than 100 acts are enacted, like the Cyber Resilience Act, DORA, especially for the financial sector, the AI Act, and so on. The NIS2 Directive provides the first general cybersecurity requirements for businesses, and the focus is businesses underpinning or providing infrastructure for a modern society to work properly. It's a directive, which means it will need to be implemented by each country, as opposed to a regulation that's kind of more directly coming into effect. In the EU, it has been in effect for a while. It was enacted in December 22. The deadline for implementation locally in the various countries was October last year. Only 6 countries made it, but a host of others are on their way. So practically speaking, for a Norwegian company or business doing business in Europe, you must basically comply with it. And soon it will be Norwegian law as well, most likely second half of next year. So we're first implementing NIS1 these days, 9 years behind. But the next one is going to come much faster. We'll save the questions for the panel, so you just take a note of the questions you have. So we have a few things we're going to go through. So which industries are affected by this regulation? This is the NIS1 scope, which is enacted now, and NIS2 will be the NIS1 plus this. How many recognize your own industry or business? Hands up. Good. That's why you're here, isn't it? Partly, at least. We can't go through all these details, of course, but you need to know the scope has been much extended compared to NIS1, also within the individual categories like energy. Now it's also hydrogen. Many more businesses because of the increased vulnerability you see. There are 2 classes of entities, essential and important, and it basically says it itself. Annex 1 of the directive will be the essential one, and Annex 2 will list the important ones. And the categorization is like the sum of the importance and the vulnerability. For example, like food, distribution is in category important. It's of course critical to have food, but it can be operated without digital means, the distribution, and people are supposed to have stock for emergency. These two categories of entities more or less are subject to the same requirements. Slight differences, but practically speaking, it's pretty much the same. Not only private businesses are subject to it, but also public entities, which is natural when you think about the public sector's important in providing infrastructure for society. Size and affiliation. Has to be some size to it, 50 employees and a turnover or balance sheet exceeding 10 million euros. That will cover most important businesses, but if it's critical enough, it can be small outfits doing very critical functions in digital infrastructure, then it will be covered anyway. There are also some quite complicated regulation on related businesses. The main idea is if a company covered by this owns more than 25% or controls more than 25% of a smaller one, then the smaller one may also be covered if the connection is tight enough. Can't go into those details either. I wrote recently an article in the legal journal Lov and Data that it's only focused on the scope, so you can go there and look for more details. Okay, so what WH? What technology? Well, we're talking about infrastructure is kind of the heading here. And this is what Article 21, which is basically listing up all the requirements, is focusing on, and that's networks and information systems. So what is a network and information system? A NIS, that's the name, NIS. Well, it's defined as an electronic communication network. Defined in the European Electronic Communication Code, basically a cable network or wireless doing signal transportation. It can also be a device that carries out automatic processing of digital data, like a computer, server, router, with logic. It has to have some sort of logic. And also digital data stored, processed, or transmitted by any of these means I just mentioned, like hard disk, RAM, tape. So it goes quite far. In other words, signal transportation, storage and transportation in networks and on devices. So when I say this, is there any question popping up in your mind? These are very infrastructure focused things, but there are many other things that keeps a hospital going, isn't it? Like software. What about standalone software working on top of this infrastructure? The directive does not directly say anything about that, but if it's critical enough, I am of the opinion it is covered, and we're going to have a little look about that. So now you know what the NIS is, sort of what I just said. You have a risk down here, always red. posing a threat to the NIS, right? Then you have support systems for the NIS. And if those support systems don't work, the NIS won't work and things will break down. So the NIS2 Directive says that technical, operational, organizational measures to manage the risk posed to security of the NIS, and an all hazard requirement means also those systems that can pose a threat to the NIS will be covered. So that's a risk too. And the measures are supposed to block that risk as much as possible. We'll return to that. So standalone system with much importance. What about the measures? Well, this is a compact version of Article 21, which is the practical one for practical measures to take. Appropriate and proportionate technical operation and organizational measures to manage the risk posed to NIS, just as I told you, and prevent or minimize the impact of incidents on recipients of their services and on other services. So it goes quite wide, doesn't it? So this means it's a risk-based approach. Less risk, less measures. More risk, more measures. To know what to do, of course, you would need to do a risk assessment. Okay, and we have some more specifics on the measures. The measure referred to in paragraph 1, the one we just saw, shall be based on an all-hazard approach, allfare, all kinds of dangers, that aims to protect networks and information systems and the physical environment of those systems, not just the logic. And shall include at least the following. These measures are just listed here. I'll run through them. But what is appropriate will be affected, by the risk level, the technological development, like what is the state of the art, standards, what will, for example, ISO 27001 say, SOC 2, what do they say? Cost of implementation, not any cost is expected to be assumed. Risk exposure, size of entity, the bigger, the more measures, likelihood of incident, potential severity for the entity itself, but also society and the economy. So the end result is supposed then to be appropriate and proportionate. Okay, so here is a good list of possible measures. We'll just quickly run through them. Won't comment much of them. This is, it's basically good cyber hygiene. Much of it will return to to the supply chain security for a moment. And to kind of translate this into practical measures, you should talk to a cyber security specialist. What about the supply chain? These guys. Many attacks will take place down. Everyone remembers the Hydro attack, I guess. That was perhaps not the supply chain, but a subsidiary of Hydro. Okay, so these are the customers, and this is the regulation. All hazards, at least supply chain, including security-related aspects concerning the relationship between each entity and its direct suppliers and service suppliers and service providers. Okay, so only one step down. Do you think only one step down? Hands up, those who think it will only be one step down, or should it sometimes be more than one step down, one level down? Hands up if you think it's only one level down. Oh, you are very clever. Okay, so the question is then, how far down? Well, it's, it says at least, so it can be more. All hazards, well, if the hazard is in level 3 or 4, then you need to do something there. The purpose of the NIS2 is to kind of place and find the risks and deal with it. So again, you need to see what is appropriate and proportionate in your supply chain. And what can you do? Well, you have agreements. You can take one at a time. You can only go for one regulation or one level down. So you must try to make a chain system in that regulation. Then you must back it up with auditing of the situation further down. So that can be a big challenge. Contract is not mentioned in the article. It's in the article itself in 21, but the preamble says that is the main tool. Okay. Well, where does it apply? It applies, geographically speaking, to any entity providing services into the EEA, EUS. So that's why Norwegian businesses will have to comply too. And of course, if they're placed in the EEA. How? Personal liability. Now we're over to that chapter. Had to be quick. A few minutes left. Under the general regulation, according to the Limited Liability Act, Aksjeloven, section 17.1, negligence is the requirement to become liable. And negligence means that what you should have done or what you should not have done. In Norwegian is called board liability, styreansvar, which is really quite misleading. It's not only the board, but it's also the officers further down, as we shall see. So this is a very high-level snapshot. First, who can claim compensation? The company itself, shareholders, members, and others. For example, creditors. That's very practical. Who may be liable for compensations? Shareholders, board members, no surprise. General manager, no surprise. Member of the corporate assembly. And then accessory liability, medvirkeransvar, which means anyone contributing to a damage may be liable. And we have cases where project managers or almost like on a janitor level basis have become liable to damage. And the conditions are there must be, of course, damage or loss, causality. It must be a connection between what happened and the loss, and negligence. Oh, 1 minute left. I gotta speed up. And negligence. And what's really interesting on negligence, what is negligence? Well, there was a case in the Håheller case in 2016 that says there is a presumption of negligence. If the duties violate, if an officer, anyone violate the duties that objectively apply to the person in question, which is scary when you see all the regulations saying something about cybersecurity. There will be very easy to overstep such an objective obligation. NIS, new invention in NIS2 is personal liability under Article 21. Member states shall ensure that the management body of essential important entities approve the cybersecurity risk management measure taken by those entities in order to comply with Article 21, oversee its implementation, and can be held liable for infringements by the entities of that article. Most likely not strict liability, objektivt ansvar. That must be specified when implemented in Norwegian law. Management body not defined. And who can be held liable doesn't really say. We can get some help here in 32, but that applies only to essential businesses. So the short answer here, it's basically, it says, you can have these slides later, so study. It says anyone, the short, look at me now, because you don't have time, we don't have time. Anyone with the authority to do something about the risk can be held liable, which means way down in the organization. Okay, the same template. We don't know who can claim compensation. Who may be liable for compensation? Management bodies, we don't know who it is. Person with authority to comply, that's as near we get. Conditions, we don't know much. Infringement of 21, that's a requirement. That's quickly done. Breach of duty. This is very, very compact, and I'm running out of time. Okay, enforcement and all aspects of enforcement, the full list. It's just what's coming on. On the sanctions side, make public administrative fine, as here, always. They can suspend certification or authority to operate, and they can suspend management. And of course, this personal liability, and that will look like this. No presentation complete today without some AI assistance. And these are the fines, quite stiff ones. This combination of sharper legal obligations, higher values, increased threats, and the increased duty of care means an explosion, actually, of liability. Well, this you can have later, or you can take a picture quickly. I won't even run through them. Apart from a couple, the first one is very important. Get the management on board and start to work with it. Make a white paper. Do risk analysis. Thank you.
So our final speaker before the panel start is Dr. Henning Schalowski. He's chair of CLYDE CO's European board and head of the firm's German and continental European insurance practices. Henning is a recognized expert in insurance and reinsurance and will present on cybersecurity threats from a global viewpoint. Welcome, Henning.
Well, thank you so much. And I hope you can hear me well in the room. Thank you again for hosting this wonderful and so very relevant cyber seminar today. Apologies that I cannot be with you in beautiful Oslo, but I truly appreciate the opportunity speaking to you, discussing some of the trends we are seeing in the global markets this morning. In particular, as we're working very closely with the other presenters this morning, and I'm sure many in the room. So for us at CLYDE CO, cyber really from the start has been a core part of our global practices. As you know, insurance is our DNA, and therefore, since the very beginning when the insurance industry started investing and rolling out cyber insurance policies, we've been very active in the various markets, assisting insurers as well as companies in dealing with navigating the ever-increasing risks in the sphere. We do that from two different ends. One is breach response, and you may be aware of our CyberOne global offering, which provides a breach response service through hotlines, legal support, and obviously the forensic PR, business interruption support, everything that companies need when the attacks happen. Next to that, of course, we're very much looking at the coverage side of things, the risks maturing for companies and insurers alike. And that is really the core of my very own practice. So from the start, cyber has been, of course, a global business. It is virtual attacks hitting companies virtually. So very different than when you look at the exposures, for instance, under property or other liability insurance policies, as it has been a phenomenon very early on already that when an attack happens, it often happens in various jurisdictions at the same time. So just looking back slightly and working our way forward to the topics of today, we're all aware that over the previous years, in particular, business interruption has been the main driver of cyber losses, and that continues to be the fact. If you look at all the risk surveys that are undertaken, business interruption always is top of the charts. I think if we work our way forward through the ever-maturing cyber market, of course, and in particular for us in Europe, 2018 and the introduction of the GDPR has been a milestone which brought cyber and data privacy compliance to the very top of the agenda, including the notification obligations, everything that's connected with breach response, but the compliance that goes much further beyond and is now further developed, as Christian has been explaining, also through the NIS2 Directive. What we've seen more recently is that with the maturing market, some of the issues under cyber insurance policies have been the focus of discussion. Certainly here in my very own jurisdiction, we've seen a number of cyber coverage actions, which mostly focus on the risk placement and risk assessment prior to policy placement. So we've now had a number of court judgments here in this country, for instance, looking at pre-contractual disclosure obligations, misrepresentation, and other potential defenses in terms of increase of risks or contributing to the insured event. So that is a debate that is ongoing. Nevertheless, so far, all these discussions have mostly been looking at the first-party loss side of things. And what I'm going to do this morning is look at the state of play with the now still evolving cyber markets and threats, and a shift, or let's not call it a shift, let's say the uprise next to first-party losses to the exposures under the third-party coverages. If we look at the developments in the more recent months and maybe 1 or 2 years, then certainly in our claims practice, we've seen a very significant uprise on the liability side of things. That includes, let's say, the CBI exposures, that is when a supplier or other contract partner gets hit by a cyber attack, and the attackers work their ways through into the systems of the insured, and that creates liability exposures, obviously, in the supply chains, as Christian has just shown on one of his slides. Connected with that is a significant uprise in recovery actions, especially against IT service providers for wrongdoings and potential breaches on the preventive side in setting up and hosting the IT security of companies. Now, the real driver, however, is the rise in class and other group and mass actions. And that's going to be one of the core topics for me this morning. And if we, when we discuss collective redress and collective actions, obviously what needs to be the starting place, well, no surprise, where the action happens, just as these days, of course, in the United States. The United States have been that jurisdiction, as always, that started very early on. And class actions in the cybersphere are, of course, to be seen in the context of the general developments in terms of US exposures. So you will all be very aware of the rise in nuclear verdicts of $10 million and more, which have been rapidly increasing in the US, especially in certain judicial hellholes like California, Texas, Florida, and New York. Those have been very much focused on product liability and precisely bodily injury cases. But the thing to note here already is that cyber and data privacy and related actions are on the rise. Generally speaking, we're now seeing verdicts quite frequently exceeding $500 million or even $1 billion. And you see the median jury verdict rose by 27% to 2023, which is the latest stats we currently have on file. Just if we look at the places you might be happy to visit for holidays, but should stay away from, ideally when it comes to litigation risks. Here's our top 10 in 2024, starting in Philadelphia and ending in Louisiana. And if one takes a look at the 50 states of the USA, you'll see the hotspots with the most corporate nuclear verdicts, and thus also the most severe impact on the insurance industry. Now, what's the reason behind that rise? What are some of the factors driving it? Well, it's the extortion efforts by plaintiffs' bars, of course. Plaintiffs and the firms driving those actions are using class action litigation and arbitration as a threat to insurers and their insurers to seek opportunities to settle early on. So again, for 2023, the top 10 settlements across all class action litigation hit record high numbers. Also in 2023, class action government enforcement lawsuits in total, in fact, exceeded $50 billion in settlements. Now, a positive fact so far, at least, has been that in data breach class actions, only 25% of the class actions filed have been receiving class certification so far, but where we're seeing, and as we'll discuss in a minute, those actions continuing to be on the rise. And of course, that anti-phenomenon is driven by a number of other factors, including geopolitical risks, recession risk, inflation, everything that's top of the political agenda these days. Again, what is important to note is that these nuclear verdicts are not limited to bodily injury. And here are just a few examples of other actions. For instance, the Californian EPL claims, or the infamous Illinois Biometric Privacy Act actions, of which we're seeing a lot under the BEPA, more recently also under the Sister Act, the JIPA, looking at genetic information. Indeed, those verdicts are spreading also, creating more and increased exposures for cyber risks. Now, very much of these exposures are still driven by state regulation in the United States. As you all know, we need to differentiate between the federal regulation and the state regulation. On the federal level, in 2022, the American Privacy Rights Act has been proposed, which in particular gives Americans the right to opt out of targeted advertising and allowing state attorney generals to bring civil actions on behalf of states' residents. And it would be preempting state laws that are covered by the bill. However, the bill has been stalled so far. We'll see what the new government and the Republican majority in the Senate will do with it. So at the moment, most of the regulation is state-driven. For instance, I mentioned the BEPA, JIPA, some of the other legislative acts, which also means that much of the litigation happens in the states and in the state courts, which precisely leads us to some of the judicial hellholes I've been mentioning. So what's going on in the US? In fact, data privacy breach claims are the fastest growing trend for class action litigation in the US now. We're seeing a projected increase in frequency of large cyber claims. For 2024, that was 17% in class action lawsuits. Looking at 2023, there were approximately 1,300 data privacy lawsuits, a number which is double to the 2022 figures. And there are other factors, and still, for instance, the ramifications from CrowdStrike and other incidents and events that are driving these litigation proceedings. There's one other reason behind the US system that has a very strong influence on that trend. That's, as mentioned, the legal landscape, that is the law firms, the plaintiffs' law firms sitting behind it. But it's not only the plaintiffs' law firms, but it is also the impact of litigation funding. Litigation funding, of course, has been another global phenomenon. We've seen in a number of jurisdictions having a major impact on the number of claims, the frequency, as well as the quantum that is being claimed. And it is now a truly global industry. Over half of the spend is focused, however, at the moment in the United States. It's providing very substantial resources to litigate claims that otherwise may not have been litigated. And that's certainly true, again, across the jurisdictions. And we'll see that in a minute when we move over the pond to Europe. There are some other practical impacts. Social inflation is to me mentioned. Insurance claim costs are rising as a result of the uptick in litigation. The costs are being socialized and to a large extent to be borne by insurers, which of course has an impact on loss ratios and potentially also on premiums. One of the discussion points, and that's true for the United States as well as many other jurisdictions at the moment, is the regulation of third-party funding, because in many instances it's not always clear whether and when a plaintiff is benefiting from private funds, and there's not always an easy way to find out. Whereas, of course, the funders in the background have oftentimes some quite significant influence on driving these actions and considering also settlements. So defendants may have an opportunity to seek disclosure of such information through discovery requests and third-party subpoenas. There's much debate over the relevance of funding arrangements, and some of the state and federal courts have already implemented disclosure requirements. So some are more critically looking at litigation funding, but it is very clear that it's a factor that's there to stay and that will continue the drive for more liability actions impacting companies and their cyber insurers in particular, but also insurers under other business lines, of course, if we look at tech E&O and ultimately also at D&O and shareholder actions down the line. So the US, as always, are in the driver's seat, but if we look around the world, and that's the other place that I'll focus upon, Europe is really that part of the world which is driving much of the risks, both in terms of regulation, but also litigation that are impacting companies in Europe, but also globally. Especially GDPR mass claims have been significantly on the rise. And if we take a look back, then I think it's very fair to say that Europe has come quite a long way when it comes to collective actions. The legal litigation landscape has been very diverse for many, many years, and some member states have been offering more opportunities for plaintiffs to group together and bring actions, and others have been more reluctant, including, for instance, my own country, Germany. However, the litigation landscape has been very rapidly evolving over the recent years. And I think that really goes back not to cyber as such, but another corporate scandal, unfortunately, again, coming from my very own country, which is the Volkswagen scandal. The Volkswagen scandal, as initiated and first addressed again in the United States, has led to massive consumer actions around the globe and especially also in Europe. And it was then that it became, well, very hard to neglect also for legislators and politicians that Europe on a broader scale was lacking sufficient opportunities for collective redress. Now, before the legislators became active, tech was actually driving some of these developments, and we've seen on the consumer front across various business sectors and legal exposures that in particular legal tech platforms have been on the rise. Tech platforms which operate, for instance, with assignment models where individuals assign their claims to a vehicle. Everything is tech driven and funded typically by litigation funders. And those tech platforms then group these claims and pursue them. There has been quite a bit of litigation over that model throughout Europe. On a broader scale, we can say it has been largely admitted as possible and enforceable. And this remains on the one side on the rise. And we see it with aviation claims, for instance. We see it with the car claims, for instance, following from Volkswagen, but also in some other product recall cases, for instance. And we're also, and in particular, are seeing these legal tech platforms driving these actions when it comes to cyber exposures. Now, as you all know, the European legislator and the member states haven't, however, remained inactive, but a quite significant development has been the introduction of the European Representative Action, which now allows consumer association to group claims together, bring such claims bundled, and also for collective redress. So a mechanism that is truly new, I think, for quite a number of the European jurisdictions, which is still very limited compared to the US class action system, because it is a process that is not driven by law firms and funders initially, but these qualified entities, consumer protection organizations and associations. But it is a big leap forward for Europe. And it in particular includes the opportunity to bring GDPR mass claims. Now, what are these mass claims that we're talking about? It is now especially the claims under Article 82 of the GDPR. I'm pretty sure Article 82 will ring a bell with most of you in the room. It is the new count that was introduced as part of the GDPR, allowing victims of data privacy breaches to bring claims not only for their material damages, but their immaterial damages. So to say, the pain and suffering when you learn that your data has been hacked, infiltrated, published, whatsoever. While these claims have been fairly dormant, let's say until 2020, 2021 still, over the past 2 to 3 years, we've seen a rapid increase. And you see that just on this list with the actions that have been brought to the European Court of Justice to clarify the requirements and prerequisites for bringing these claims. You see them listed on the left side, and it's quite plaintiffs friendly on balance. It starts with the necessity of an infringement of the GDPR, and while the burden of proof is on the claimant, it's actually mostly in the defendant then to show that the defendant had the necessary technical and organizational measures in place. So that goes right back at what Christian was saying about NIS2, for instance. So much of the burden will actually be on defendants to show that they were compliant when it comes to these terms. Now, the second prerequisite is material, or rather, and then that's been the focus of the debate, non-material damage. And while the burden of proof is on the plaintiff, the core question really is how high is the threshold, and we'll look at that in a minute. But there needs to be a causal link between the infringement and the damage. And again, however, the burden is on the defendant to show that there isn't. And the same is true for fault. Negligence is sufficient. And importantly, the negligence does not necessarily need to be with top management, but the company is looked at as a whole. So quite plaintiffs friendly. The amount of compensation then is really left to the member states. The burden of proof is with the claimant. There are no punitive damages in Europe, of course. So center of the debate has been oftentimes what are the losses that can be actually claimed. And you see on the right-hand side, one of the leading cases in this country has been the scalable capital action, where we actually had a judgment a while back awarding one single plaintiff 2,500 euros. Now, that in itself isn't an exposure that would necessarily frighten companies or their insurers, but if you take into account that, for instance, in that case, supposedly more than 30,000 customers had been affected. And if you then do the math, you land there in numbers beyond 80 million euros in exposures. And you see that this so far a rather dormant and smaller exposure through the developments on the side of the substantive law, the requirements under Article 82, but also under the procedural law with the new opportunities to bring these mass actions has been significantly increasing. Now, a few positive messages mixed with, however, also some risks, and that is mostly from this country. You'll see that we've also had, actually, we've been seeing probably a few hundred judgments around these actions across the country. These are three of the more significant ones. What you see is that the numbers actually awarded have been going rather down, 100 euros, 500 or 400. That said, still, if you do the math, and you have 10,000 claimants, of course, the exposure is quite significant. However, why these decisions have been called toxic, and I'll be with you in a second, is in particular because the threshold for the non-material damage has been quite significantly lowered, and a mere loss of control, for instance, is sufficient to trigger those claims. I just need 3 minutes to finish. As I mentioned, on the United States, litigation funding has been a driver and is a driver there. I mentioned it's a global phenomenon. It's just precisely as true for the European Union. And what I want to just flag here that for those interested, the European Commission has just very recently published a very comprehensive report mapping third-party litigation funding in the European Union, looking at the player state in the various member states, including the regulation, and very likely, and going back to a proposal that is now 2 or 3 years old, the European Commission and the Parliament will look again at regulating third-party funding, and some of the proposals are already in this paper. So that will be here to stay. I'm finishing my presentation just with 2 final remarks. I think the core message is that liability actions are on the rise and are now a significant threat to companies and their insurers. Not to forget, however, and I'd like to share just 2 very important developments also when it comes to enforcement, is the side of GDPR fines. Again, there has been quite a bit of litigation and a few cases been decided by the European Court of Justice. I won't go into detail here, but the judgments have again been fairly friendly in terms of the authorities enforcing breaches of the GDPR. And then just looking at the numbers since 2018, based on our statistics, we're now actually at more than 5 billion euros in fines for companies levied by the authorities in the various member states. So what I've been saying at some of the other discussions I'm involved in, what the nuclear verdicts are in the United States are more and more the fines we're seeing, including under the GDPR, under European regulation on European and other companies. 2 final remarks in this. A very hot debate remains, of course, the insurability of these fines, and we may wish to cover that in our discussion later on. But quite significantly recently, and some of you may have seen that, the French regulator has published a statement saying that under French law, still subject to the scrutiny of the courts, but in the regulator's perspective, company fines are not to be insured, at least under French law. That's one. And the other very significant development, and that goes back to also Christian's topic, which is the interface between cyber risk, compliance, and management liability, is the question whether companies that have been sanctioned with a fine can actually turn around and seek recourse from their DNOs. We've just very recently, in February this year, had a hearing at our Federal Court of Justice, which is the highest civil court, which is not in the context of a cyber or GDPR fine, but an antitrust fine, but just as relevant. And the core question was there whether such recourse is admissible under liability law or blocked by the ordre public, public policy, due to the sanction purpose of the fines. What the German Federal Court of Justice has done is sent this case to the European Court of Justice because the antitrust fines are based on European law. And we expect the European Court of Justice to come back with its response likely in 1.5 years. Why am I mentioning that? Well, for 2 reasons. First, recourse in the GDPR and data privacy context has also been on the rise. And second, of course, the company fines that drive much of this recourse are also based on European law. So it's quite likely that the decision we need to expect on the antitrust side of things, likely in 2026, will also have implications for the opportunity to take recourse by companies when a GDPR fine is levied upon them. And likewise, of course, for the exposures of cyber insurers and D&O insurers alike. So a lot happening in the cybersphere. Thank you very much for your attention, and back to the room.
So good morning, everyone, or God morgen, if that's how you pronounce it. That's the only Norwegian that I'm going to be doing today. But my name's Niall Mackenzie, and this is my colleague Brandon Wilkerson. We're both cyber underwriters in our London office. We've both got key focuses on the Nordics, and today we're going to be talking around the winning the battle against cyber risks. So briefly, just an introduction to BEAZLEY. We're a global specialist insurer which was founded in 1986. We focus on 5 lines of business, with cyber being our sort of flagship product. We're currently the largest cyber insurer in the world with 1.6 billion gross written premium. And I think what's interesting about BEAZLEY is that cyber is between 20 to 25% of our total portfolio. A key driver in the growth over the next few years is going to be the Nordics and European business. Currently, our Nordic book is sitting around 30 million in premium, and yeah, we're going to see a lot more growth within Europe over the next few years.
So what's driving a lot of that growth? I think that's one of the main questions that we're seeing here today. That's one of the main reasons why you're in the audience, and we're seeing cyber be a huge proponent and a propeller of where that growth is all across Europe. So in 2024, most recently, right, the global cyber market has reached 15 billion. That's expected to grow to 29 billion over the next couple of years, and that's a huge part of why we're here today and where we see it happening in Europe. But you're asking yourself, well, why is that? Why is it growing? Number one is the frequency. We know that there's more awareness occurring simply because there's higher frequency of cyber events happening. We're seeing the regulatory environment, that landscape is changing annually, even more frequently. There was a great conversation previously about the EU regulation, GDPR, NIS2, DORA. All of this is having an implication on your D&O, on your cyber. What are you doing to maintain compliance, and how do you protect your businesses? Businesses are also becoming more digitized. You're seeing, just an evolution of businesses moving to the cloud. You're seeing a lot more focus on how you protect your network, whether that be from the external perimeter, then what happens once the threat actor gets in the environment, how are you protecting your business there, all the way to your backup security. And so there's a flow chart that's occurring. And a lot of businesses are asking the question, what tools do I use? What products do I use? How do I manage that risk environment? And that goes all the way from the cyber insurance landscape, as well as to the vendors and the partners that you're working with. And that's why you're starting to see so much growth in the market. And that's a lot of what we're going to cover today on where that's happening.
Yeah, so what we're going to be covering today is the common cyber risks and how you can protect against them, how you can protect your cybersecurity along with insurance and how that can help, the key coverages of cyber insurance, and a ready to buy checklist. So the baseline controls which we asked for, which has been derived from our claims history and the claims data that we've gathered over the past few years. And yeah, it's more so how insurance can fit into the overall security framework and how you can build that resiliency.
I wish we could stand up here and tell you that the threat environment is more sophisticated and that we're seeing the same risks that are happening daily, and that these risks have changed from 2019. But the fact of the matter is that it hasn't. You might have threat actors that are becoming a lot more sophisticated. You're seeing tools like artificial intelligence. You're seeing the cyber transformation happen digitally. But at the end of the day, we're still seeing the same risks. One of those being ransomware, one of those being weak passwords and multi-factor authentication not being deployed. You're seeing phishing training. There's no substitute for human error. The tools that you put in place, of course, are meant to mitigate and help that. But one thing you can't solve for is human errors. Retrospectively, how you protect your business is where it's most important. Again, it goes back to the tools that you're using. How are you training your employees? What access controls do you have in place? These are all things that businesses should be considering and contemplating, as well as brokers when you're advising your clients. Do you have a checklist in place to say, how are you protecting your perimeter? How are you protecting your internal environment? And what are you doing if somebody gets into your network? Do you have the right backups in place? Because what we're seeing on our end is it's still the same low-hanging fruit. It's quite boring, actually. It's not as exciting as it may seem, but we're seeing the same risks, the same losses that happen simply because the baseline controls aren't in place. And some of that we'll uncover today in terms of the ready-to-buy checklist. But it's amazing how quickly the cyber environment and landscape changes, yet the risks are staying the same. And we're not always seeing businesses adapt and evolve with that. And so some of it is coming, with our conversations about this is what the regulatory environment is looking to try and establish. How should they protect themselves? And this is where it becomes a key partner for your insurance providers as well as with your brokers who can educate businesses to say, this is what insurance companies are providing to you. This is where you can get the resources. This is where we can help. But in turn as well, brokers also have to have the resources too, to be able to provide that value to the customers and say, again, here's the key exposures. This is where we can support you. You look at the claims environment, and while it is quite small at the moment, it is projected to increase. And you look at the day-to-day and you say, well, you have driven a car for 20 years and never had an accident. Does that mean you don't need auto insurance? Now, there's a difference in terms of auto insurance being compulsory, but at the end of the day, it's being prepared and having the right resources and tools in place so that if something does happen, you're going to be protected. And a lot of that is what we'll continue to talk about today. But by and large, the risks are staying the same. So it's all about how do we educate policyholders, how do we educate clients to be an improved risk and improve their own security posture and uncover things that they may not have even thought of before, such as having multi-factor authentication or making your password something different than the 6 characters that you've used for every single account since you were 12, right?
Yeah, and I think the vendors that we work with, they're seeing the exact same issue still. They say that they're like a broken record in terms of trying to get clients to implement these controls. These are still the methods that threat actors are using and exploiting. So I think here it's important to state that with a cyber insurance policy, you're buying it. The main focus for buying it is it's going to pay claims, but that's not all it does. It's not just a piece of paper. It's not a product where you buy and then wait till the next year for the renewal terms and then engage with insurers 2 months out. It's something that you should be constantly reviewing and engaging with your insurers with, having that back and forth. And I think it starts with, the risk landscape is constantly evolving. There's emerging threats all the time. And when you're going to buy cyber insurance, you should be thinking, how does your cyber insurer help you with that? So, for example, are they having monthly meetings with MI6, ex-FBI agents? Are they trying to get into that, the knowledge that these sorts of high-level people have of the threat actors and the risk landscape? Are they helping you improve your cybersecurity infrastructure? For example, selected vendors with negotiated rates. There's been stories of clients where they've saved a lot more in money compared to their premium. So saving 60k when they're buying a new cybersecurity product and their premium is only 30k. Instantly that pays for cyber insurance. Are they helping you with risk management training? A global insurer will have a global perspective on what they're seeing across clients of all sizes and all cyber risk landscapes, and threat actors act differently all across the globe. So it's important to get a true global perspective, and they're helping you with data analysis. That's the really invaluable data that you're not going to get anywhere else. We see all sorts of claims coming in through all sorts of revenue sized companies, all sorts of industries, and it's invaluable data that we can pass on to clients.
I think when you look at a quote or policy, the first thing most businesses turn to, even brokers, you look at the policy premium, right? And you compare it to see what else is out there in the market. But what isn't shown in the premium are the risk management offerings that most carriers are likely already providing or should be providing. one of those Niles mentioned is discounts. Oftentimes your carriers are going to have relationships with vendors, whether that be endpoint detection products, SOC providers, MSSPs, vendors that your companies are actively looking for. And so if you're going through a tender process, it's worth inquiring with your insurance providers. Say, do you have any relationships that we can leverage where we can get a discount off of what we're providing? More than likely, they do. There was a question about how do I report, questions for the board, right? How do I gain support or get leverage? Many carriers, if they don't already, can also support conversations that you're having at a board level to help uncover the need or the reason why we should either be purchasing cyber insurance or these are the benefits of that risk transfer. It's more than just a piece of paper. And I think you're seeing insurance move from just that indemnification claims process to a lot more of the value-added services that come along with it that isn't seen in just the policy premium. And that's one of the best benefits I think Niall and I get out of largely working in Nordic countries is that it's very trust focused, it's very relationship oriented, and there's a true need from businesses that say we want to improve our own security posture. And that's where we as an insurance company are really able to add that value to provide those services and say we have the expertise, we have the claims experience, we see these globally, and we can often help where you may not know who to turn to or where to turn to. And we have the resources and tools to be able to do that, either engaging those conversations with you or again getting support from higher up.
Yeah, and we have a cyber services team which helps clients with improving their cyber resiliency and helps with those risk management tools. So, for example, you should be looking at if your cyber insurer can help you with threat intelligence data. They can provide you with risk management offerings such as workshops, tailored workshops to clients that will run through ransomware scenarios, business continuity plans. It's all about that mutual benefit. If a cyber insurer can improve a client's risk posture, it's more unlikely they're going to have a claim. And if they can keep that engagement up throughout the whole cycle of the insurance policy, it builds that trust and relationship. And in a time of crisis, a client will want to be able to talk to people who they've talked to before, have a good understanding with them, and try and contain an incident as quickly as possible. In a cyber incident, minutes really do count. And that's where, when you're looking at cyber insurance, you should really look at what is the incident response team looking like? Is it full of legal and IT security experts? What are their relationships like with legal vendors, forensic companies? How quickly can these vendors step up when they are in a time of need and a time of crisis? It's really building that trust and relationship and making sure that everything's ironed out, the process is in place should they need to call up the cyber insurance and make sure that the policy kicks in. For example, another really strong reason why cyber insurance is so important is a lot of these companies will have large retainers. For example, the ransomware negotiation firm that we use, their retainer is around 90k. If you buy the insurance, you're at the top of the list for them to work with you and try and contain and bring down that price of a ransom demand, should that be the case. You get access to all of these expert companies, and that's really what you're paying for, to get that expertise and make sure that your business can be up and running again as quickly as possible.
Yeah, I think before we get into the coverage, and what I would ask you to leave, ask yourself in terms of this slide is what is my takeaway? We know that the claims environment is minimal, right? And so you ask yourself, well, I'm not seeing claims. Why do I need cyber insurance? At the end of the day, it's for the expertise, it's for the vendor relationships, it's for the services that come along with purchasing the coverage. It's not just a piece of paper. And so it's better to be prepared. It's better to have that transfer, even if the claims environment aren't quite there. We know it's coming, but at the end of the day, having that relationship with an insurance provider that can provide that support, whether it be through your broker or through the businesses, is a key component of where we're seeing. And it's not just the premium, it's more than that. And so I'd ask here, this is one of the most important elements that I would say is the takeaway is, we're not seeing the claims, why do I need it? This is what I would look to.
Yeah, and seeing it as an extension of your cybersecurity team, having someone you can call up, get an opinion without triggering the policy. It's more just making sure that you've got that understanding between yourselves and yeah, having that open dialogue to ensure that an incident doesn't turn bigger than it needs to be.
Not all cyber policies are created equal, but more often than not, you're going to get the same level of coverage. One of the first and foremost is the breach services, right? So when you have an actual or suspected data breach or security breach, and the key part is actual or suspected, right? You could have an incident that you don't know if it's gone anywhere. You might say, you know, I don't know if data's been compromised, but I want to check. I don't know if somebody's in my network, but I want to check. This is the most common insurance agreements that are triggered in a policy. Being able to pick up the phone as an insured and just call and say, hey, I think there's something going on, but I'm not quite sure. I want to check. Getting that expertise, getting that advice, having a legal forensic, having a legal party come in and understand what are your repercussions, what's the regulatory environment like, who do I need to notify, understanding and having those resources available at a moment's notice is invaluable. Having a forensics investigator to be able to look into your network and uncover, is somebody in my network? Should I be concerned? Having that built into the policy is one of the most important aspects, and it's one of the most frequently triggered insurance agreements that you see in a cyber policy.
I think going into the other areas of what the actual policy will cover, so you can split it up into first party and third party. So you've got your business interruption. This will also cover dependent in business interruption. One of the most important things to consider here is what is the dependent business interruption actually covering? Does it extend to non-IT vendors? For example, if a manufacturing company relied upon a logistics firm in order to carry out their business activities, does it extend to that? Does it extend beyond just IT vendors? And then you've got your cyber extortion. So in the event of a ransomware attack, if a threat actor is demanding X amount of money in order to unlock systems and ensure that you can continue your business operations, the cyber insurance would kick in. We'd work with a cyber extortion company that would run the sanctions checks to ensure that you're not going to be breaching sanctions law, paying a sanctioned entity, and they would do all of the negotiation for you. Then your data recovery costs, e-crime, and then breach response services like Brandon was just mentioning. You know, that's one of the most important things of breach response services, your access to the legal, the forensic companies, PR. More times than not, it's important what you don't say than what you actually say when you're potentially notifying customers, and that reputational damage that you could potentially get. And then you've got your third party coverages. So your payment card liabilities and costs, your media liability, then of course your data and network liability, regulatory and defence penalties. We see a lot of claims from this. You know, if an assured is potentially liable for certain data being breached, we'd cover the defence and penalties that come along with that. I think, like we were talking about in the last session, the data and network liability environment in Europe is a lot less than the US. The litigation is, of course, a lot bigger in the US, the culture is, but I was chatting to a law firm last week, and it doesn't necessarily mean that Europe is not going to follow with the US in years to come. It's just more the culture at the moment is not really in that litigation environment.
We'll wrap up with two slides. First one is being considerations, and I'm sure you're asking these questions quite frequently when you're looking at insurance. Is for one, what data do I hold? You know, could I be potentially liable for that? What's the regulatory environment? You know, are there fines and penalties that I could be liable for if I don't protect my consumer data the way that I say I am or that I need to? It's understanding the business impact that it could have to your company. Is there a business income loss that is prevalent should you have a cyber attack and your operations are shut down? Are there any data network and recovery costs for somebody to come into my network and actually investigate the incident? Is that something that I'm liable for? And it's understanding and asking businesses these questions, even as a broker, even as a CISO, as a risk manager. Again, what could go wrong, right? What could I potentially be liable for? And I think these are becoming a lot more prevalent. A lot of these I can't say it for certainty that it's always going to be preventable, but you have a lot of low-hanging fruit that can be avoided simply by improving your security posture. So even though you have a liability to your customer, to your business, there's certain controls in place that we view as baseline, the minimum standard that companies should put in place in order to better protect their business. And they're quite often regular cadences that you may have in place already, but oftentimes we find companies don't. And that's where we'll conclude today on our last slide now.
Yeah, so we've worked hard with third parties to establish some baseline controls, which we view to be the absolute minimum criteria when looking at buying cyber insurance. So you've got your 3 ones in pink there, which are absolutely critical. So your endpoint detection, which is basically like an antivirus system, MFA for remote access. Again, it's amazing how many clients just still don't have this in place. And I think when you're not working with cybersecurity on a day-to-day basis, I can see how MFA would maybe be a bit of an annoyance. It's another, hurdle to jump through when you're logging into your work computers or whatever. But it's such an important control to have, and it's so easy for threat actors to penetrate and compromise systems without it. And then it goes into, these are the other recommendations we'd have. So offline backups, incredibly important. If your systems get compromised, you can't get into your system. So a threat actor will have much more leverage if you have not got any offline backups, which you recover from. Phishing training, again, it's a very basic tool, but it's amazing how many companies still don't invest into having that as part of their cybersecurity infrastructure. And then your more maybe developed cybersecurity products, such as your EDR and your security operations center. Again, with your cyber insurance, you should be asking the cyber insurer, do you have discounts? How can you help me with implementing these tools? And open that dialogue, because the better risk, the better infrastructure that you have, the less likely you're going to have a claim. So it just benefits everyone involved.
All right, and with that concludes our portion of the seminar.
Next, we are pleased to introduce Scott Aamodt. He's the head of professions and financial institutions at LOCKTON in Norway and has long experience with insurance.
So hello, I'm, as I said, a reinsurance broker from LOCKTON. I'm going to make a very short statement about this. We're one of the 10 largest brokers in the world, and we're the largest privately held. I know there are people from Marshare who actually probably felt a bit insulted. But I think we're sort of large enough to know what we're talking about. And this is going to be the shortest presentation when it comes to number of slides. And I'm going to start with what are a broker supposed to do when we talk to clients about cyber insurance. And I represent a part of LOCKTON who operates in operational risk. So we normally talk about liabilities and the things that people do that can go wrong. So that could be internal crime, could be external crime, could be liabilities produced by the company itself or by the employees of this company. And cyber insurance is sort of borderline to that these days. It used to be very operational. It used to be when it was introduced in the beginning. It was anything that could go wrong with your IT system was supposed to be covered under this. And then it goes back to the fact that insurance providers are commercial industries and they are like to be profitable. So what do you do if you realize that the risk you're taking on is a bit too big? Well, you start to decrease it. So it's a bit like the market these days has a variety of insurance clauses that makes this insurance a bit different than what it used to be in the beginning. And it varies a bit between nations, and it varies a bit between markets. So I'm just going to talk about sort of when I am a company and I am looking at my IT system and there's an issue there. We all know that. Going back to what Defendable said, you might have a virus in your system that might be 3 years old, and you don't know about it. So when you look at it, you say, all right, I could buy an insurance. I'm going to come back to that. Does that work? Or I can increase my security. So I'll spend the same amount as I do on my insurance buying added security. And a lot of companies in Norway have done that traditionally. And there are reasons for that. And one of the reasons is, of course, that there are limited numbers of claims in Norway. And in particular, on the liability side, there are a few very well-known incidents where you've had sort of cyber attacks on companies who have lost their ability to produce, but it's not common. And a lot of companies will be able to sort of work old-fashioned style, pen and paper, and it won't really hurt your business that much unless you're producing something and you use robots and stuff like that, who are absolutely necessary that this works. But when we talk about sort of the, what should we say, the choices I have to make, then it goes back to what do I want the cyber insurance to provide for me? And if you look at sort of fire insurance, if there's a fire, I call my insurer, they take over, they send a surveyor. The surveyor says that this is a fire coming from what then? I don't know, lightning, and it's no problem. You'll get a new house or whatever the claim has happened to. This one is a bit different. And we're going to talk about two issues which are very apparent. And it's behind sort of the, what shall we see, the front end of the insurance. Because when we talk about this, we say that it's going to cover you for your own losses. So we're going to do reconstruction, we're going to cover business interruption and all that stuff. That's on the face of it. And we're going to cover your liabilities, which is also sort of, what should we say, not that common in Norway. But before I go into sort of the issues with a couple of these, the first party cyber insurance is a named perils insurance, which means it has a few things it covers. It's not an all risk, so whatever cost you have, it's not going to cover all that. It covers specific items written down in the policy. And for the third party cyber insurance, some of you might have other liability insurances. Those insurances will sometimes cover your liability if you have a cyber incident. A lot of you will have these LMA exclusions, which will take away any liability caused by a cyber incident. And then comes the question, if you don't have that, does it still cover financial loss or just liability? Because if it covers only financial loss, it will not cover the GDPR fines that Henning was talking about. So how you structure this and how these insurances interact with each other is, or should I say, important for the protection that a company gets. So, and this is just repeating what Beasley was talking about, so that's not that important. But this is the first of two slides. And this is the first party cover. So, when Brad and Niall was talking about their reconstruction, the insurance from its origin was, what shall we say, designed based on companies having their server in the basement. So something happened, you pick up the phone, you call the forensic company, they come riding in, they find out what's happened, and you reconstruct. And if you have a business interruption loss, that will be covered as well. Well, the world isn't like that, is it? Because it's outsourced. We outsource to everyone. So I might have, 5 service providers. They provide sort of the platform, they provide my software, and the only thing I have in my house is a PC. So what happens if I actually woke up one morning and it says crypto or septo or whatever the file system is called when you push that phishing button? Do I call my forensic firm? That's what the policies normally say. You call your forensic firm. Okay, so what if you have an outsourcing agreement and there are contracts behind that? So in our experience, when you talk to some of these service providers, they say, all right, I see what you're saying, but nobody touches my system. So then you can't get your forensic firm in there. And if you can't get your forensic firm in there, how do you prove your loss? So then you have to talk to your service provider and they say, all right, can you provide this? And then it gets interesting because some of the policies says you need a statement from an outside expert. So if you need an outside expert's opinion before you can get paid, so what's the value of the insurance then? And also, going back to what I said about the Norwegian tradition of just calling your insurer if you have a claim. Most of these insurances will state that you have to prove your own loss, which means you either call your own people or you call the forensic people at the insurer who are not allowed access. So who do you call them? Obviously, you have to make an arrangement with the service provider, and not all insurers are very interested in having the same service provider who might have the attack from somewhere else giving the proof of loss. So that's basically, I like the fire myself and then I claim. Some insurers will accept that, some will not. And going back to what you saw the report that Defendable put up there. I think, and I might be stupid, but in my view, it's not very clear how to prove a loss in this area. It's a bit easier when it's a fire. So there is, not talking negative about anyone, but I think that loss adjusters in insurance companies might not understand all of that. So you need a third party to say that this is a valid claim. And if that valid claim comes from someone who's not outside, well, this first wording won't pay anything. So when you look into this, how are you going to do this? So, and that's the job of the insurance broker. So when we talk to companies about this, we have to find out how many service providers do you have in your system, and interesting cases comes up when you have, what then, 4 service providers. 2 of them is being approved by the insurer. They can do this themselves because it's reputable companies or whatever. But the others are, what then, 2-man bands. And they say, no, we're not going to have anything coming from them. And then what do you do then? Change them or debate with the insurer or lose your insurance. So, well, this is direct copy from someone. So, and from as you can see here, I think a lot of companies are not used to being the project manager for claims themselves. So even if the policy has a forensic firm that is preferred to come in, it might not be that they can come in. And if you do something with this one, let's say you have this wording, you have to agree with the company that this may be the service provider, maybe a forensic team, someone has to come in and do your, what should we say, project management of the claim. And the other thing I'm going to talk about is what I started with. That's the liability side of it. Because there are, if you have service providers, most IT companies we come across have excellent lawyers. So what these excellent lawyers do is that they're limiting their liability. And it has to be that way as well, because if you're a service provider and you have like 1,000 clients and you have a claim and you are not able to pay business interruption for 1,000 clients, that's just a fact. So you need to limit your liability. But what if someone uses you as a mule to get through your system into your client's system? This is in fact the insured in this case, and it moves through there and into your client, and it kills your client's system. Who's liable then? And who's going to pay for it? And let's say you are liable. You're the insured and you're liable. What then? And then you say to the insurer, yeah, well, I'm liable, so you have to pay. And then the insurer says, well, could I have a look at that contract, please? Because I'm going to make a recourse against the service provider who has actually allowed this to happen. And you've limited your liability, and the insurer says, yeah, I'm not going to use those words, but they say that you're on your own. So and this is very much an interaction with some of the other insurances you might have as well. So you might have a general liability insurance, you might have a PI insurance, and you might even have a crime insurance, which could be triggered by this. But it has to be written down that there's a subrogation waiver if you do have that type of contract. And also make sure that your liability insurance has the word liability and not financial loss. Because if it has the financial loss term, it won't pay the GDPR fines. And basically that's it.